Okay, everyone, good afternoon. Here we are. We have a tremendously distinguished panel today with us to talk about an opinion that is truly momentous and has had already a very big impact and is going to have a big impact for the time to come, for a long time to come. And that's the Schrems 2 decision. I'd like to introduce my co-host, Justin and Tony Pillay of Wirewheel, who will be introducing our wonderful panel today. So, Justin, it's all you now.
That sounds great. First of all, Dan, great to see you as always on our regular broadcast where you and I tackle some of the harder issues that have come up in the privacy world or whatever's on the minds of folks in this world. And I think it's fair to say this is one of the larger, most significant privacy decisions that have happened in a long time. I know we've just gone live, so we usually like to take a minute for folks to actually join the broadcast. So I'm going to take a second while we're getting started to introduce a phenomenal panel that we have convened and reconvened today to talk about Schrems 2. So first, all of the panelists that are joining today were involved directly in working on the Privacy Shield adequacy decision. So our entire group of panelists is very steeped in the issues that actually come up on an adequacy decision, both from the commercial side and from the national security side. And so I'm delighted to introduce you one by one, and then we're going to frame up the discussion for today. As you know, as we all know, we also did an introductory, very quick reaction to Schrems 2 yesterday, and that is also available for folks who want to catch up on a quick reaction. So Gabriela Zanfir Fortuna, welcome today. Gabriela is with the Future of Privacy Forum. Also writes extensively on EU privacy issues, probably one of the more widely followed blogs and sets of guidance on EU GDPR Privacy Shield guidance. And obviously was with the DPA before, in the DPA office before, as part of the Privacy Shield negotiations. Welcome today, Gabriela.
Thank you very much, Justin. Hello, everyone.
Great to have you here. Jocelyn Aqua, welcome, Jocelyn. Jocelyn's joining us today as she is a partner at PricewaterhouseCoopers, PwC. Jocelyn served in the national security community, in DOJ, in Office of Director of National Intelligence, and participated directly in the Privacy Shield and Safe Harbor discussions. A very experienced privacy professional, helping companies obviously now, but a very long career in the government and in the national security space. Jocelyn, welcome today.
Thank you. Nice to be here.
Great to see you. Ralph Sauer. Ralph, welcome. Ralph is the Deputy Head of Unit International Data Transfers with DG Justice. Did I get that right, Ralph? I feel proud if I got it 80% correct in terms of pretty good. Ralph obviously was also deeply involved in the Privacy Shield negotiations on behalf of the European Commission and a lot of other adequacy decisions that have been going on around the world, deeply involved in GDPR as it went through the trilogue, and is here today to contribute, I think, a lot to the conversation in terms of how the Commission and Europe actually sees the significant decision in Schrems 2. So welcome today, Ralph.
Hello to everyone, and thanks for having me here.
Yeah, terrific. And then Bob Litt. Bob joins us from Morrison & Foerster, also a very long career in the national security space, served as the general counsel at Office of Director of National Intelligence during the Obama administration, and was the author of the underlying letters in the Privacy Shield discussions that are the subject of extensive discussions in the Schrems 2 decision. So, and of course, myself, Justin Antoni Pillay, I'm the CEO of Wirewheel. By the way, welcome, Bob. Great to have you here today. I'm sorry, I didn't mean to cut you off there.
That's quite all right. Thanks, Justin.
Justin Antoni Pillay. I'm the founder and CEO of Wirewheel. Dan and I are delighted to bring this to the community. We know that Schrems has brought a lot of confusion, a lot of stress. It's also huge privacy. It's a huge human rights decision, and will have a lot of consequences to our community for a long time to come. I'm going to take a moment to just talk for a minute because we've done some summaries as a team of what Schrems really means, even at a high level. We've also done a quick summary, which I'll post shortly, that summarizes the top line holdings of Schrems and some of the things companies need to do today. So headlines from Schrems 2. First of all, Schrems 2 held that Privacy Shield, one of the major data transfer agreements or frameworks that enables the movement of data from Europe to the United States, either physical movement or the processing of data on a transatlantic basis, used by more than 5,000 companies, Schrems held that Privacy Shield is invalid. And that's a very significant decision, certainly for the 5,000 plus companies that are operating under Privacy Shield right now. We'll talk about what that means and some things companies can do, but that was one of the more significant holdings of Schrems 2. The second major implication or holding or result of Schrems 2 was that a second major means of transfer used by companies to move data from to the United States or to process it, move or process, are standard contractual clauses. And the court held on its face that standard contractual clauses as a principle, as a general means of transfer, are a valid means of transfer. However, the court also held that controllers must make a determination when they're using a standard contractual clause to transfer data to a particular country. For example, if you are using the data, the standard contractual clause, to move or process data from Europe into the United States, a controller has to make an individualized determination that the recipient country, you can actually protect the data consistent with the principles of Schrems. And a very significant part of the Schrems 2 decision explains why, in the view of the European Court of Justice, there are very significant problems with moving data to the United States. So there are a fair number of holdings around standard contractual clauses, and we're going to talk about that as well. And the third major, group of issues arising out of Schrems 2 is because Schrems 2 struck down Privacy Shield, and because it adds additional analysis to how to think about standard contractual clauses, it opens up a pretty significant line of international dialogue that needs to be to happen next between Europe and the United States on the next round of adequacy and how do you deal with these existing means of transfer. So huge decision. even for us, we hosted an initial session, just the reaction for folks trying to understand what this means and what the consequences to companies are. It's mattered to companies all over the world. And it matters to small, medium, and large companies because of the way data moves all around the world at this point. So with that introduction, we have a lot to talk about in our session today. And I thought I would start with a discussion of standard contractual clauses and what it really means under Schrems. So here's the question I pose to the group. And Ralph, I might start with you on this one. Okay. So the critical question is, what is the import of the Schrems II decision to those using standard contractual clauses today to move personal data or process personal data from Europe to the United States specifically? One line of analysis says the court validated standard contractual clauses as a means of transfer so one can use them. And an entire other set of honest analysis, I think, right now says the court held that the privacy shield fell because the restrictions and the redress mechanisms related to intelligence collection made the United States a jurisdiction to which one cannot transfer data. And so that impacts, obviously, using standard contractual clauses in that way. So with that framing, Ralph, understanding that the court validated standard contractual clauses generally, what's the import in your view and for the rest of the panelists to trying to use standard contractual clauses to move data to the US as of today?
Okay, thank you very much. Obviously not an easy question. It's also not, as you said, not an easy judgment, let's say, to digest. It's quite a complex judgment because it deals with different instruments, and on top of that, it deals with particular questions of government access and what the, let's say, the legal rules on that, the limitations, the safeguards should be. So there's various elements which comes from the fact that this was what we call a reference from a national court that asked a number of questions to be clarified by the Court of Justice under EU law, and the court basically goes through that program of questions. So, but to come to what you ask, I mean, it's clear that there's a change from the situation that we had until yesterday. We have in the EU under our data protection laws rules for international data transfers. We don't prohibit international data transfers, but we have rules that frame these transfers that require certain safeguards, and in particular aim to ensure that the protections that data is afforded in the EU is not undermined when it leaves the EU, because it's in the nature of data that it can easily be moved around. It can leave a jurisdiction, go to another. And if you would only ensure the protections domestically at home, then that's certainly an incomplete protection, because you could easily transfer the data elsewhere and process it there, maybe then bring it back. And in the meantime, there wouldn't be those protections. That's why we have rules that seek to ensure that. But they are of a different nature. There is an adequacy finding. That's the most comprehensive tool in a way, and it's basically a finding, a determination that and it can only be done by the European Commission. It's a finding that a third country has rules in place, has a legal regime in place, but also practices that ensure what the court said is an essentially equivalent level of protection. If that is the case, and this is based on a detailed analysis, then data can flow freely to that third country as if the third country was part of the EU internal market in a way, for the purposes of data flows. But that's not the only mechanism, and then there are a number of other ones, and in particular contractual tools. And the standard contractual clauses are the most important contractual tool, and also in general the tool that's used most widely. And obviously it's a very different way to ensure the protections, because it relies on contractual commitments that the parties to a contractual relationship, to a commercial relationship, take how to protect the data, and to facilitate this, the Commission has adopted model clauses that in principle companies can take. That was at least the idea, and plug them into their overall commercial contract, civil law contract, and can be sure then that data is protected, and that was meant to then allow as well the transfer. And this, let's say, this mechanism in principle has been confirmed. So the court, by confirming and declaring as being still valid the standard protection clauses. We have different sets, but I don't want to go into details of that. But declaring these standard protection clauses as still valid confirms in a way that this mechanism is still one that can be used to transfer data, and that's an important clarification, and including taking into account the fact that there's of course one element that or at least one element that contractual rules cannot tackle, namely what public authorities in the third country, so the country of import, might do with the data in terms of requesting data, accessing it. That's obviously something that private parties cannot tackle. But the court has looked carefully at the mechanisms that are part of these standard protection clauses in terms of how to deal with a situation where there might be, let's call it disproportionate government access or not sufficient limitations and safeguards around that. And the court has also, and I think that's also important, has found that the mechanism that is there in terms of the parties checking, or taking, I hope I'm still, okay. The parties assessing the situation, the importer working together with the exporter, and potentially the exporter going to a supervisory authority, that this mechanism is okay to address the issue. But then what is also clear, and that's I think where the judgment, of course, becomes then more difficult to apply. The court has said, nevertheless, the outcome has to be the same as for an adequacy finding. So it has to be ensured, the data export has to ensure that when transferring the data, an essential equivalent level of protection is ensured. And so what has changed is in a way that now the court has clarified the responsibility on the parties in the first place to make that assessment, and if the assessment is negative, if it turns out that the essentially equivalent level of protection can no longer be ensured because of the rules and practices on government access, then the transfer has to be suspended, or at least then the advice of the supervisory authority has to be thought, and the supervisory authority might have to suspend the transfer. So there is now a lot of responsibility on the contractual parties and the data protection authorities, the supervisory authorities. But at the same time, I think it's important to note that the court made at least two, or provided at least two hooks for possible solutions. And those are that on the one hand, it has made clear that this is a case-by-case analysis in which the parties, but also the data protection authorities, can and should take into account the circumstances of the transfer. That is an important point. I will come to the need for further interpretation of this, but that is one important I think, avenue to look into what that means, and how maybe one transfer can be distinguished from another. The second one is that the court has said, well, there are these model clauses, the standard contractual clauses, and they, let's say, address the average case of a transfer. They don't take into account specific issues that might arise in terms of government access in the country of import. And it has said that, well, but parties can supplement standard contractual clauses with further safeguards. And I think that's the second avenue that will have to be explored. What could be these additional safeguards? And it will depend. It will depend on the, let's say, challenges that you face in a particular country. And you will have seen, or you perhaps have seen that today the European Data Protection Board, which I think is the body that has to now apply the judgment and interpret it when it comes to these two aspects, has already announced today that they will provide further clarifications and guidance. And I know that they have mandated a group of data protection authorities to now work intensively on exactly doing that. So we will have to see sort of what will be the criteria, what will be the type of measures that they will come up with. But I think those are the elements that one can use and see, even in the situation where, and that's now specifically for the United States, where the court has, of course, also in its judgment identified already certain challenges and problems, and on that ground has annulled the adequacy decision. How one could perhaps tackle those with additional safeguards when using standard contractual clauses, or to what extent can the circumstances of the transfer maybe mean that these problems are not as relevant for one type of transfer than for another.
So, Ralph, do you mind if I just push one turn on this? And then I think we can open it up for some discussion, because part of this might be we just don't know today. But I want to push a little bit even on the two concepts. Because what you're calling out is there's a line, a sentence in the decision, and it says, the use of a standard contractual clause theoretically is appropriate and a controller can use it if, in its view and in light of the circumstances of that transfer, those clauses are not and cannot be complied with in that third country, and the protection of the data transferred that is required by EU law cannot be ensured by other means. Okay, so there's that. This is this concept of look at the circumstances of the transfer and or the other restrictions. Okay, so but in the actual portion of the decision in which the court is talking about the reason that Privacy Shield is inadequate, it focuses, for example, on the fact that there's no effective remedy for a data subject in the United States, fundamentally because of the restrictions on standing to sue to an independent tribunal in connection with a national security request, for example. Okay, and there's clear Supreme Court judgment that we talked about yesterday. So as an example, and then the separate point, they said, okay, separate from the right of effective redress because of the standing cases, those are US constitutional standing cases, there's a separate set of principles based on the fact that the actual ombudsperson was not independent. And that runs into issues under the appointments clause, again, a constitutional US issue. In light of the specific findings of the court in Schrems with respect to Privacy Shield and the adequacy of US redress and independent review measures in the US, what are even the theoretical kinds of restrictions on the circumstances of the transfer or on restrictions that accompany can assess in light of that language? Like, how is a controller supposed to make an assessment different than the language that's in the actual Schrems decision right now?
No, I don't think the point is that a company should come to a different result in terms of the analysis of the legal framework and practices in the third country, like in the United States. And in any event, the court has clarified some of these points, and so not even an institution, a public body, could come to a different assessment. It's what the court has said. I mean, at least in the EU, this is what we are bound by. But at the same time, I mean, starting from as I said, the circumstances of the transfer, well, there might already be certain types of transfers which are, for example, less prone because of the type of the nature of the data, the purpose of the data for which it's sent, are less prone to be subject to national security interventions, interference, surveillance, or because of the recipient, because the recipient might not be one of those that can be, for example, the addressee of certain types of measures. Well, I should have started with saying, I mean, we are in the beginning of the analysis of the judgment, what it said in particular about U.S. law, or where it sees the issues, and what this could then mean for the possible solutions. But I'm just floating some of the possibilities that could come to your mind, where the circumstances of the transfer could play a role, and if there is no or a much lesser risk of interference because of the nature of the data or the type of recipient of the data or the purpose for which it was transferred, then maybe also the issue of redress will not arise, because of if you don't have the interference in the first place, then obviously the redress is not the issue. That I'm not saying that will be sort of an overall solution, but those are things which one should think about and explore, and which I would hope the European Data Protection Board will look into, whether this can play a role. In terms of additional measures, and again, I'm just sort of pointing you to maybe one things that I've also heard already, and that certainly people are thinking about. I'm not saying that this is necessarily the answer, but for example, additional security measures might also be something which address certain issues such as bulk collection, or maybe any type of collection. There might be forms of strong encryption, for example, that might prevent that. I hope Bob is not now contradicting me in saying the U.S. intelligence apparatus is always able to get beyond a strong encryption. But so I'm just saying, I mean, that might also be, for example, a type of measure, and that's something that parties, of course, can agree to, how they treat the data, how they secure the data. That might prevent government access, and therefore the issue of the limitations of government access might be less relevant, and also the issue of redress might be less relevant. All of this is not to say that it wouldn't be much better if we would tackle, let's say, the big issues that indeed the court has sort of addressed, or where it sees the challenges, and that relates, for example, to redress. Indeed, certainly it would be good, and I think. I think it befits any country to think about whether it's not judicial redress isn't something which is maybe a universal right rather than only a citizen right, and whether that's not something one should work on, or in terms of overcoming the problems of standing by at some point, at least, when there's no longer a risk for the investigation, to notify individuals so that they can show what is called injury in fact, I think, in US law. So like an individual concern by a surveillance measure, and that might overcome the difficulties that the standing doctrine raises. So it would not be about changing the standing doctrine, which would require changing the constitution, but it might tackle the underlying issue and other things. But I think that's the kind of dialogue on these much broader issues that we will hopefully have together with our US partners, and to see and those are difficult issues. Now we're quite conscious of the fact that this is sensitive, that this goes to important, fundamental questions of constitutional questions, questions of a legal system and legal tradition that are not easy to address. But we hope to have a dialogue on this, and of course it would be much better to tackle it at this level. But we're all mindful, I guess, of the fact that this is not going to be done overnight. So indeed, we need to think about other interim possibilities and solutions.
Well, and that's Ralph. That was a great summary. I do want to go to the rest of the panelists and get the perspective, because Ralph, believe me, we get it. This is a hard day to try to cover everything, and it's only day 2. So there's a lot of process, and I do appreciate you citing to the EDPB just guidance that more to come, because that does give you a sense that the DPAs are working on it. But I might go Gabriella, Jocelyn, Bob, Dan, in that order. Give me your sense about how one thinks about the practical problem for a company trying to operate under SCCs today in light of that opinion. How do you think about it?
Well, first of all, I would like to say that I agree with Ralph's assessment entirely. So it's true that a controller will not be able to decide otherwise than the court did with regard to individual redress and all of the points that Ralph mentioned. But at the same time, it's also true that the court itself pointed to specific problems under Section 702. So then of the FISA Act. So then we have to ask ourselves what companies are subject to that Section 702. One of the things that I liked about the judgment yesterday was that the court was really courageous, and just said, look, this particular act we don't like, and this particular presidential directive, and this particular executive order. In the first Schrems judgment, if you all remember, the court made some general type of assessments, said the findings there were about, a national law of a third country that does this or does that. But this time, it really looked at 3 particular acts with names and numbers. So this is also something to take into account. This is why I agree with Ralph's assessment, because it's really a case-by-case assessment. And unfortunately, this is very complicated and will require a lot of time and energy spent into finding some solutions. I know that in terms of measures to be used, I again agree with Ralph. This is also something that I was mentioning yesterday. Think of technical measures. The GDPR usually has the habit of mentioning organizational and technical measures when it deals with accountability and security obligations and so on. So think of, we need to brainstorm and see if there's anything that we can bring on the table that's both organizational or technical in nature, and that could help with whatever the court identified as being the key problems. Again, in terms of practicality, yes, SCCs can be used, with this entire huge caveat that we are just discussing right now. I know that the Berlin DPA, and this is something that's coming up into our stream of comments, the Berlin DPA apparently issued a press release today with guidance telling all Berlin-based controllers not to export at all any data to the US. I will have to read the press release exactly to get a sense of the precise language used in that guidelines. But also remember that the court said, the DPAs will need to come to an agreement on this. I mean, the court itself says that the EDPB, if there's going to be fragmentation, and we have the Berlin DPA prohibiting all transfers, and we have maybe the, I don't know, Polish DPA, or one of the other DPAs allowing transfers, they will have to come to an agreement in the EDPB ultimately. So this is my comment for now. And yes, let's look to the set of criteria with which the EDPB will come up with.
By the way, I'm going to go to Jocelyn next, but obviously it wasn't just the Berlin. The Berlin was a crisp call, and I didn't think it was limited to just Privacy Shield, but we could talk about that. But you also have the Irish DPA broadly calling into question all SCC transfers. It causes a lot of stress, in the middle of that, Gabriella. But let me make sure, Jocelyn, Bob, Dan, quick reactions.
Yeah. So my reaction, I agree. It causes a huge amount of stress. Right after Safe Harbor was invalidated, hundreds of companies in the United States were calling the Department of Commerce to figure out what to do, because I think companies are really, they're trying to do the right thing. They were trying to do the right thing by joining Privacy Shield. And while some companies had the belts and suspenders of SECs, a lot of them didn't and are in a bit of a panic. And when the court is saying things like SECs may not even work because of government access to data, well, then how would BCRs really work? How would a code of conduct or some sort of certification really work? And how would really derogations work? Nothing really works if the underlying concern is government access to data. And so what I've been talking to a lot of my clients about is just figuring out how to be operationally adequate and how to make sure that your program is strong, and to continue working on that part of it to make sure that you're doing what you're supposed to be doing under GDPR, under all of the privacy commitments you've already made, under Privacy Shield, and to just move forward, because the burden can't really be put on an individual company to assess the intelligence capabilities, because it's not just the United States, of course. And while this was a deep dive into U.S. intelligence capabilities and a rejection in part of them, this was never done with any other country. You have all of the other countries deemed adequate, like Israel and Canada in some respect, and Argentina. I don't think they had that deep dive into their intelligence capabilities and their law enforcement redress options. And then again, you have all of these other non-adequate countries. Most countries in the world are not deemed adequate. So what are they supposed to do for all of them? And then again, there was a little bit of a frustration on my part, because I just don't think that same level of essential equivalence was looked at internally. There was just that recent decision at the Supreme Court in Germany, and there are definitely different standards for collection and wiretapping for pure criminal purposes in Europe that don't necessarily add up. And then of course you always have China. So when you're asking companies what to do here, they're really spinning, and it would be my perspective for them to really focus on what they can do and what's within their capabilities, and not these political matters. I mean, moving everything to data localization is really going to harm trade, and I don't know if that really helps, because data still needs to come to the United States for these big multinationals. So I think really focusing on the practicality of keeping your programs strong and having really good accountability, so that you could share that with a regulator if they were to ever ask, show the sustainability and the continuing privacy controls that you have on your program. So that's kind of where I've been thinking that is the best place for our US and even EU companies that are, participating in this invalidated agreement.
Jocelyn, great points all around. And I think you're right, practically. And of course, there's so many small and medium-sized companies.
Yeah.
Right now in the cloud, it's really a tough situation if you're, not able to get advice, as quickly. Bob, over to you, and Dan next. Bob, maybe.
So I'll try to be quick. Couple of quick points. I want to emphasize a little bit what Jocelyn just said there, which is we've been focusing entirely on the United States. This decision applies worldwide. Any company that exports data out of the EU to any country anywhere in the world, under this decision, has an obligation to assess the privacy protections in that country to make sure that data that it is sending to that country are going to be protected up to EU standards. And that includes places like India and China, where a whole lot of data is sent. And there's, I can't emphasize this enough, the exporting company is obligated to assess the privacy protections and to stop transfers if the privacy protections aren't adequate. So that's point number one. Point number two is, I think you need to divide U.S. companies into two categories. The ECJ decision focused on two U.S. surveillance authorities, one of which is Section 702 of FISA, and that only applies to a select group of companies called electronic communications service providers. If you are an electronic communication service provider and you are subject to Section 702, and to pick up on something Ralph said, you're not in a position to say, well, I'm not likely to receive this kind of order. If you're not an electronic communication service provider, but you have your data stored on a cloud service provider that is an electronic communication service provider, then your data is also vulnerable. So people need to really think about, where is my data going and how can the government access it? Third point I want to make, and this I think is picking up on Ralph's comment, kind of his snide comment directed at me about encryption and U.S. intelligence capabilities. I think that companies are not going to be held to perfect knowledge. I think companies can make their assessments based on what's publicly known. There's been probably more revealed about U.S. intelligence capabilities than anywhere else in the world. And I think companies are entitled to take that at face value and make their assessment of data protection based on what's publicly available. And finally, Jocelyn, I think, made passing reference to the fact that European member states may have a variety of different laws and standards governing their intelligence activities. The fact is that the Court of Justice made very clear and explicit that it did not give a damn what the member states in the EU actually did, that they were basing their judgment on sort of the platonic ideal that the GDPR embodies, and that's the standard that third countries have to meet, regardless of whether or not EU member states meet those standards.
A great number of points and a lot to react to. I can see Ralph is ready to jump in on a few, but I do want to make sure I give Dan a chance to comment as well.
So I really liked your point, Bob, because I think that a lot of people critique the EU as being hypocritical when it comes to surveillance. Well, they're not. You have a lot of surveillance in the EU itself, and governments are, but ultimately the standard that they have really is external facing, not internal facing. It really is about other countries and outside the EU, and for various political reasons, they don't look internally. And so I think the pointing internally, say you do it too, is not really productive. I've never thought it's been a productive argument, and I think we really need to think about ultimately the standard is what happens, what are other countries doing. The question I've always had is what exactly is the standard of adequacy? And what does it mean? And I've never been able to really get good guidance about what exactly the standard is. What must a country do? What must the U.S. do to actually meet that standard? Do we have to change standing doctrine? If we didn't have Clapper versus Amnesty International, would that solve it? Do we have to shut down the NSA, or would getting rid of the third-party doctrine in constitutional law do it? Would a federal statute do it? What would meet this standard? And I've never gotten a good answer from the court on exactly, what meets the standard. Just a lot of sense that we don't meet the standard. And I do think that the U.S. law is actually very poor. There are a lot of problems with the law that regulates government access. The complaints that I've made and other academics and various others have made about the law, the law enforcement community and the intelligence community vigorously pushed for all these powers and enjoyed the gaps that the Supreme Court opened up in the law. And I've always said, like, be careful what you wish for, because the pendulum will swing back. You might create some problems if you overreach and create a law that's unbalanced. That's what happened, and that's what we're seeing now. We're seeing a comeuppance. Now we're seeing that there are consequences for overreaching and creating what is a inadequate body of law. And that is what we're now dealing with, which is a big impact to commerce. And it's really now, getting companies involved to say, hey, if you just clean up your law, US, maybe we could have it a lot easier. But your problem, your mess is now spilling over to us and is hurting us. Ultimately, I think that maybe the answer is going to be encryption. Encrypt the data so that the law enforcement can't get it, or that the NSA can't get it, and just try to come up with ridiculously strong encryption and keep the NSA out of it entirely. Ultimately, I think that we're seeing more encryption come into place, and maybe that would be the answer at the end of the day, that would prevent law enforcement access. I mean, I always thought in a balanced approach would be law enforcement access with the appropriate court orders, such as warrants, and so it doesn't fall out of Fourth Amendment protection. I always thought the best approach is a balanced approach, but we haven't had a balanced law and a balanced approach in the U.S. So now we have self-help measures and just encrypt it all, and shut the law enforcement out of it entirely, and shut national security out of it entirely. Actually, I'm not sure that's ideal, but I think that's where things are going. And so ultimately, there might be an encryption solution, to which case, companies can say, look, we encrypt all this data. There's no way they can access it. And therefore, if that's the case, then maybe they could move forward. But I can think that's really the only plausible way that I can think of, because otherwise you're playing a guessing game. What exactly is adequate? And I don't see how any company can look at make that analysis of, what could possibly be adequate in the U.S. law, and they can't really change the U.S. law. So I also...
I'd be curious what your thought is, and maybe Ralph too, about the court cites essentially equivalent. Like, it's like adequacy means that you're essentially equivalent, but what are you essentially equivalent to? And I think that is the issue that you're saying. I don't know the answer either, because I haven't gotten that. That if you're saying that it's not that you're not looking at anything internally, but what are they comparing it to be essentially equivalent? And maybe that's the wrong standard.
Well, and Jocelyn, I think that is a very central question. If you don't mind, I think we've all done the first round on SCCs. And the takeaway right now is, on their face, they're valid. There's something controllers have to do, not clear what. There's hopefully some guidance coming from the DPAs and others about where this goes, but I think there's a lot of TBD here. I did want to spend a moment just for Privacy Shield companies, if we could get your all's reaction. There were 5,000 companies. A lot of them are small and medium-sized entities, Ralph and Bob and Jocelyn, Gabriella, Dan, this, that are doing the right thing. The Commerce Department issued guidance saying, you certified under Privacy Shield, we're going to continue to enforce. There's a public statement, and I think a lot of the companies are just going to continue to do the right thing. We certainly are, right? We're going to commit to follow the principles because, of course, it's the right thing to do. But the benefit of Privacy Shield was, if you were doing the right thing, you had some benefit. You could benefit from that. And right now, it's a little unclear what you do, because if you look at the actual decision, it says go to the derogations. And Ralph, we talked about this yesterday, that derogations aren't typically supposed to be used in a general business way. There's limitations to the derogations. And it's a little unclear what the meaning of the court's decision was right now. Like, as of right today, what does a privacy, maybe that's the question I would ask you. In light of the court's language, if you were a Privacy Shield company, you're one of the 5,000 companies, what do you do today to feel, especially if you're following all of the principles to do business?
You're on mute, Ralph.
You're on mute.
Sorry for that. I mean, I was just saying, I hope we also get back to some of the other questions, but because I certainly have some reactions on what was said, but I'll wait for you to give me the word on that. On your question right now, I mean, one thing is clear: not the privacy shield, but the privacy shield adequacy decision has been invalidated. So that means the privacy shield, or let's say the importer being a participant to the privacy shield is no longer no longer provide a basis for a data transfer. That is very clear. The adequacy decision no longer exists, and the court had been asked whether, in case it was considering invalidating the privacy shield decision, whether there could be a grace period. Sort of, I mean, that's one thing our courts can indeed do. They can sort of postpone the effects of a judgment for some time. But the court was asked, and in the end, and you can see this at the end of the judgment, decided not to do that. So that's clear that as of now, and actually in a way retroactively, the decision is null and void. I wouldn't say that this means, and that won't satisfy you, but I wouldn't say that therefore there is no benefit of being in the privacy shield framework. I mean, I should say that I think on our side, the data protection authorities will make it very clear what the situation is in terms of the privacy shield. So I hope there won't be misunderstandings that companies might want to still rely on the privacy shield. But I have already seen that the Department of Commerce has put out a notice that they will continue the framework. That's something that is a U.S. decision to do that. I think there's still benefits to that for the companies, perhaps, because I would assume that you also market that as a element of trust for customers, because that's how you protect the data that you treat for commercial purposes, and I think that has a value, even if it doesn't concern the transfer from the EU. I understand that this wouldn't satisfy you as the full answer. So then we have discussed standard protection clauses. And I should also say that, and I'm not scolding companies here, but there was a risk to the privacy shield decision. I think was clear from day one in a way, because it's not just the case before the Court of Justice. There was also an annulment action which was brought and had to be brought within 2 months of the adoption of the Commission's decision against that decision. So in a way, it was clear from, let's say, 2 months after the adoption of the decision that there was a risk, at least, that decision might be annulled by the court. I'm saying this because, well, that at least could have led you to consider alternative transfer tools, such as ACCs. We now know that their use is maybe also not that easy, but at least that's something that would have been possible. If you don't have either one of these tools, then indeed what would be left, and I'm not saying, I said before that I don't think that the ACCs cannot be used in any circumstances, or when you add certain safeguards, perhaps. But let's say if you consider that that's not the case, then indeed you are left with what we call derogations, and that's basically another word of saying there are certain statutory grounds for transfers in the GDPR. They only concern certain situations. They have conditions, and there's guidelines that the European Data Protection Board has adopted to interpret them. but you ask a sort of more fundamental question: can they be used? First of all, my reading would indeed be that they can be used. I said yesterday that I wasn't entirely sure, because there's a part in the judgment which says that let's say the standard of a transfer should not undermine the protections in the EU applies to the entire international transfers chapter. But on the other hand, there is this part at the end of the judgment where the court had to decide on whether or not to sort of give a grace period, where the court said that's not necessary, grace period for the privacy shield, because there is always Article 49, that's the article on the so-called derogations. So I would read that indeed as meaning that you can use derogations, but they have a number of conditions and limitations. And they're certainly not the ideal way of transferring data from a privacy perspective. That's also something one should clearly say, because they don't give the protections that, for example, standard contractual clauses would give. But they're still there, and if you look at the statement put out by the European Data Protection Board today, they also refer to the derogations, but they also refer to their guidance on that. So I think I would invite or urge companies to also have a look at that guidance to see a bit what are the conditions for the various statutory grounds for transfers. But they are available.
Ralph, thank you for that. And I get what you're saying, and I think that does help a lot, at least to know that they may be available at this time. I didn't want to, by the way, stop anybody from reacting to each other. I wanted to make sure we at least had the chance to talk about Privacy Shield, since it was one of the major holdings of the decision. And there are a lot of companies. Ralph, look, by the way, I'm not the marketing guy at the company, but I will tell you, putting up a banner on your webpage that advertises I'm Privacy Shield certified at a moment that it's just been declared dead and struck down all over the world is sometimes suboptimal from the marketing side. You know, like, I think saying that I follow the principles, saying that we're privacy protective, I think that's going to be a big deal. But, you know, like, catching the eye, when you look even broadly, most of the things right now on Privacy Shield aren't advertising it. And it does become a challenge, you know, candidly. But I did want to let everybody, there was a lot we covered on both as standard contractual clauses, the national security side, Privacy Shield. Certainly, Gabriella, Jocelyn, Bob, Dan, any other, or Ralph, what are some other things you all would like to react to each other that might be helpful for the community that's joining us today?
I have two quick points. First of all, you know, when I was mentioning that standard contractual clauses can still be relied on, obviously, we need to know that we're not in the same situation as on July 15th. So definitely things have changed. You know, I mean, you can still rely on them, but I think it's just under extraordinary circumstances, and you need to, you know, apply this entire set of thinking around measures that can be additionally broad, thinking whether you have any risk to be subject to a Section 702 FISA Act order or in anything like that. So we're not in the same situation as 2 days ago. However, you know, there's this option that Ralph very well detailed. So that's something that I want to be clear about, so I'm not misunderstood. The second point, and I absolutely, it's such great points that Professor Solovey made a moment ago. I would say that there are some indications in the court's judgment of particularly what the issues that need to be fixed are in order for the for this framework of the U.S. Legal environment to be deemed adequate by the Court of Justice. And it was very interesting this time that the Court of Justice stopped at the first condition for an interference with the right to private life to be lawful. And that condition is particularly to be provided for by law. And that law needs to have certain limitations for this type of interferences in it. So there are a couple of paragraphs, and for example, 176 around there. 176 is actually a very good one, because in particular it highlights, what kind of definitions of limitations or a scope of these limitations that could be used in a presidential directive or in an executive order or in a law, indicating some circumstances that put some sort of limits to surveillance of content of electronic communications. So there are some indications there, but I agree that this is definitely a big open question. Exactly what could, in a dream world, the US do in order to satisfy this stringent tests?
So let me follow up on that, Justin, because I know a number of people participating have asked about sort of practical things that companies can do. If you look at the defects that the court found, they found that the U.S. intelligence collection was not proportionate, that there was not sufficient individualized judicial or independent authorization of the targets and scope of the surveillance, that there were not judicial remedies available to persons who have been the victims of surveillance. These are not things that companies can fix. There may be workarounds that companies can do, the sort of thing that Rolf mentioned. If you're in a position where you can say, well, none of my data is ever going to be subject to this kind of intelligence collection, that might help you. But the bottom line is, this is going to have to be fixed at a government-to-government discussion level. And I think, first of all, I think from the United States side, they're going to have to show some flexibility on how it conducts its intelligence operations, which is going to be very difficult because there's the U.S. is not going to want to fundamentally compromise its capabilities. And frankly, most of the countries in the European Union rely very heavily on the U.S. on the intelligence the U.S. collects, but the U.S. is going to have to find ways to be a little more flexible. At the same time, the Commission is going to have the difficult burden of trying to reach another accommodation with the U.S., recognizing that the U.S. is not going to go as far as the European Court of Justice would ideally like, but to reach some kind of accommodation that will work in the practical sense and that the court will accept. So in terms of what companies can do in the short term, I think one of the most productive things you could do is get your government relations people working both sides of the Atlantic as hard as they can and emphasizing the importance of getting a political resolution to this issue.
That was a tremendous amount of, that you covered there, Bob, and I agree with everything you said. Dan, Jocelyn, Ralph, I want to make sure you all have some space to react as well.
I mean, I've just been trying to figure out what is the good guidance to give to all of these companies as they're trying to navigate all of this when there really is, just like Bob said, outside the scope of anything that they can handle. I'll be looking forward to seeing what the European Data Protection Supervisor, like that board, and the kind of guidance they'll give as the additional safeguards. I think until that happens, of course, relying on derogations, but also making sure that you maintain the appropriate safeguards within your program, I think is just going to be essential. And I'm really, I look at the level of effort now that's going to have to happen with companies with all their vendors. If you have thousands of vendors and each one of them maybe are, looking to see whether they have Privacy Shield as their sole means of transfer, what does that mean for all of these companies? What can they do in the short term, medium term, long term for the next 6 months to make sure that data can flow in their companies? And I don't have great answers there, except to say, like, there are a lot of companies that are just not staffed the right way to do these assessments. And so the advice to them would have to really be focused on doing the right thing, making sure that they've managed to keep their data protected and all of those kinds of privacy and security controls that we always recommend. And I'm looking for greater guidance to give to them in terms of that next step of what Bob had said and others about assessing each country's capabilities and where their data should flow. I think that's going to cause a lot of churn, and I'm looking forward to some clarity to help navigate this.
I think what we're seeing too is this is a political move. A lot of this is politics, and it's somewhat of an ingenious play by the EU to, in a sense, make U.S. companies have a stake in national security surveillance and the development of that law. That the companies will start to lobby the government to fix this. Come on, guys. You can fix this law. That there are ways that you can create judicial remedies, have more review, have church committee type of bodies that look into what surveillance agencies are doing, as we did before. There are a lot of improvements that can be made to our law. They're stalled. ECPA is 40 years out of date. We've got a lot of problems, and we can do a lot to fix it. And I think getting companies to see our economic interest is tied to the finally cleaning up the mess that the law is right now is a good thing, and we just have to do it. I don't think our current government is quite up to that task, unfortunately. But I would hope that we could do something. The other thing I also wonder is suppose we negotiate a new Privacy Shield 2.0. Or we will call it a different name, something else, because it's Safe Harbor to Shield. I had to change all my training to have shields rather than harbor imagery. So change it, Privacy Safe or whatever it might be next, and come up with a new one. It's slightly better. Just that Privacy Shield was kind of a slightly warmed over. Sorry, Justin, but it was very similar to Safe Harbor. A couple more things thrown in, a little stronger. So let's say we push it, they push it again, come up with something. By the time the Court of Justice looks at that and knocks that down, it could be years. So we buy ourselves some time by negotiating something, give up a little bit, come up with a compromise. Might not be perfect, and then at that point, let that work its way out. Let Schrems fight that one down. But ultimately, that will buy us a little time. Then hopefully, we can do more work on improving our surveillance laws when maybe our government might be a little bit more functional. So maybe that's a strategy that government can take. I don't know. But, I think whatever we do, it's going to be a muddle through. I'm not sure we just throw in the towel and say, okay, we shouldn't try to do Privacy Shield 2.0. Why not give it a try, even if it might, not necessarily survive, and at least it might be worth a try.
Yeah, and Ralph, I want to give you a chance to comment here. I will say we've gone an hour. We've had an incredible reaction from the community to these briefings. Thousands of people every day are engaging. Dan and I are certain to bring, if you wouldn't mind, this group back together to sort of talk about this, because there's a lot to cover, really. Ralph, I have a few points I was going to make, but I wanted to give you a chance to react as well.
No, I mean, indeed, I think it's important to react at least on some arguments that were made, or points that were made. I mean, on the last one of Daniel, I mean, just to make very clear that this is not some kind of plot that we have sort of arranged and we have sort of put our court out there to hold US and European companies hostage so that we can somehow influence US surveillance laws. So I mean, I know that you don't mean this, but I want to be very clear on this. I mean, we would have wished, and we have defended this shield with various stakeholders and in the courts. And as Justin will remember, and Bob, we also fought quite hard at the time when we negotiated the Privacy Shield to get as much as we can in terms of safeguards to make it a solid instrument. So we're not happy that the decision is annulled, and it's certainly not meant as some kind of way to put pressure on a foreign government. This is our court. adjudicating on a fundamental rights issue that is quite important for various reasons that have sometimes to do with European history in terms of the value of privacy, and it is what it is. And I think you have in the US other fundamental rights that are very dear to Americans, like freedom of expression, that I think you have equally strong sentiments and maybe case law on it. So just to say that's one important thing, and we're ready to engage with our US partners that we take seriously, and we know their limitations, but we'll try to work with them. Then there's all these arguments about double standards, which you know that we don't share that view. We don't share the view that there's a double standard vis-a-vis our member states. I'm not saying that there might not be practices sometimes that might not be in line with what the court is setting out. That's why we have national courts and we have the European Court of Human Rights in Strasbourg, which has a 50 years case law on national security and surveillance, and has annulled many laws and practices. Also at national level, we don't have just the German court case recently. We have several, the UK courts, other courts, French courts have annulled measures in their countries. And now, importantly, we also see that the court is making very clear that this is also an EU law question, not just the European Convention on Human Rights, which is not EU law per se, but it binds all EU member states, but it's also an EU law question under the EU Charter of Fundamental Rights. And I think we will see that the court will also in the future apply this much more also to the national security activities of member states. And there's a case before the Court of Justice that you might have heard of, Privacy International, where I think this will become quite relevant. Although it concerns the UK, so I'm not quite sure where that case might end up now that the UK has left. So I don't agree that there's a double standard. And when it comes to third countries, well, certainly what the court has now decided, and Bob said it, applies globally. I mean, those are rules which exporters have to now apply globally. And yes, the case focused on the US because Max Schrems, who is the student who didn't like that his data was transferred from Facebook Ireland to Facebook US. That's it's your success, I think, in the US of having the most prominent social media companies that led to this case being focused on the US. But it could have been maybe in today's world, it would easily focus on China, because I guess we are now also having more and more social media data going there, and this is where the case arose. So, but the rules apply across the board, and the same applies, of course, for adequacy. So I and then the last point I wanted to make, I mean, because there was this, what is actually the standard? What is the court actually doing there? I mean, I fully recognize and share the view that this is a huge burden on companies. So again, this is not something which we would have preferred as an outcome, to be clear. And that's why we today, for example, in the meeting with the European Data Protection Board, have very much insisted that there has to be help for companies. There has to be assistance. There has to be clarifications. They need to be accompanied in this difficult task. But that it is what our highest court has decided. But then in terms of the sort of the applicable standard, I don't think it's all that difficult. There's a number of things that the court takes issue with, where it's actually not even about the substance. It's about the transparency. It's about the rule of law, that certain things should be in the law so that individuals know about this, and there's sort of legal certainty as to what applies. That's, for example, I think what the court says when it comes to 702 FISA, that the actual limitations, which might come from the targeting rules, which are sanctioned by the FISA court, but they are not in the law, and therefore there's no stability as to what they might be from one period to another period. That's I think one of the issues. Or it's about necessity and proportionality. That that concerns questions like maybe bulk collection or mass surveillance, although the court doesn't even use that term. And then, of course, it's about rights and individual redress. That, for example, concerns the question, why is there a presidential policy directive, PPD 28, that indeed ensures important safeguards for foreigners? And I think that's a great thing that the US has done. But why does it then say at some point, but that does not give enforceable rights to individuals? Why does it do that? And therefore exclude that you can actually invoke these safeguards? That's a question. And then there's the question about redress. And I read the judgment as saying that, at least in this area of national security, it doesn't necessarily have to be judicial redress. Of course, this would be much better. But there can be something which is of a similar sort of independence and impartiality. And we had tried to work on this with the ombudsperson. But it was a US decision to use an established person, the senior coordinator under PPD 28, which happened to be in the State Department, and build the ombudsperson mechanism on that. One could have maybe made different choices, and maybe it wasn't a good idea to go down this path, and we wouldn't have a judgment that addresses that. So, well, I mean, I'm looking at Justin and Bob. We had all
Ralph, those were great points. And so here's my suggestion. First of all, I'm gonna wrap up, and obviously folks can weigh in with one final point. Although I know we planned this for an hour, I'm going to summarize with 3 critical things that companies need to know. But I'm also gonna, if you don't mind, Ralph, react in a couple of ways, and I suspect my reactions may want you to come back and respond. Okay, so the 3 critical things companies need to know: Privacy Shield is invalid now. It's not a stayed decision. So there's no Privacy Shield transfer mechanism, crisply. If you're a Privacy Shield company, you need to look at another means of transfer. And the court itself points to the other derogations in GDPR. Number 1. Okay, that's the number 1 thing you need to know. There is no Privacy Shield. The second thing you need to know, standard contractual clauses are okay in principle. If you have them, you probably need to look again. That's what I would say. Just look again, because there's guidance in the decision that says you have to conduct some kind of analysis. And there's a little bit of we need to wait and see, but you definitely need to look again. The third major takeaway is there is a fair amount of stuff we need to wait for, including engagement between the US and Europe. And I've seen very good signs that that engagement is going to take place. And Ralph and everybody here really summarize some areas where we might want to engage. We can talk about this in a minute, but I have a couple of observations just having listened for the last few minutes, and maybe I'd start here. I am not I don't view looking backwards in a the emperor is dead kind of way. So I don't look to say, now let's burn the history of the emperor. And so to react to Dan's point a few minutes ago, I think to say that to undersell what is in Privacy Shield, I would react in 2 ways. Number 1, Safe Harbor and Privacy Shield enabled thousands of companies to make broad and very important commitments to protect privacy beyond what is required under US law. And let's not forget that. It materially moved forward companies just volunteering to do it. And nothing in this decision said that those commitments weren't valid. There was not a huge trail of companies being found in violation of that. And that's something to think about, because you did, through an engagement, end up moving companies forward. And when you actually look at the decision, Dan, Ralph, even now we're sitting here honestly struggling on the national security front, trying to figure out what more we could do consistent with US constitutional law. I'm not saying, Ralph, we couldn't have done more or we can't do more. There's obviously some rooms to move, but it's a very difficult mental game that most of us are playing, trying to map out what's the next move. So it's not entirely clear that there weren't meaningful protections, nor that there was a tremendous amount of room consistent with the Constitution, Dan, that you have. There are things we should do, but there are a lot of domestic political issues that we have to take into account. The second major observation is a lot of the court here is coming up to the edge where you might end up with some concerns about the validity of a court judgment. So imagine, for example, Ralph, we get to the point where an ECJ opinion literally bans movement of data because there's no way to fix it under US constitutional law. That's the opposite of where you end up from a Marbury versus Madison perspective, where you're validating the ability of a court to make a judgment. And it gets out there at a certain point. So I do think the court is getting close, but I think there's a lot of political room still here to go. And we did not spend any time today talking about the consequences of this to Brexit, to the adequacy decisions that, Ralph, you have helped lead in other parts of the world. There's a lot there. I mean, Brexit, how is that review going to take place consistent with UK collection law? And how are you going to wrap that in? And how does the are the adequacy decisions in Japan and other parts of the world going to come to pass? It was very interesting to me to hear Max Schrems say today, look, Brexit's a mess, so I just didn't bother to bring it up. But it's got to be of issue if that's, if you're looking at it really equally around the world.
Justin, I'm sorry to interrupt here. I've enjoyed this, but unfortunately, I have to go because I have a client who wants to be advised. What do I do now about transferring data? So they're expecting me on a call now.
I think we're all there. And let me just say, on behalf of all of us, we are going to come back together. I hope you guys will join us back. Ralph, thank you for joining. And Gabriella, Jocelyn, Bob, thanks for joining Dan and I. Dan, do you want to close us today?
Well, thank you all for joining us. This has been a really fascinating conversation, and I think the start of many conversations about where we go from here. What do companies do in the short term? What do they do in the long term? What does the government do? And what's the next? What is the future for Privacy Shield? What's coming next? What should be done there? A lot of interesting questions to come in the future on this. So I look forward to discussing it with you in the future. So thanks for joining us, and thanks everyone for tuning in. Have a great afternoon.
Thank you all.
Thank you.
Thanks, everyone. Goodbye.